Hi everyone. So we are going to take the topic GYANVAPI Mosque Row, so which is a contentious issue that was going on from past week. So now we are going to take the topic in detail. So even it is from the mains perspective. Okay. So first of all, before going into the issue, I'll give you why it is in the news. What is the issue? See, 5 Hindu women, they filed a petition in civil court. Initially, these 5 women made a petition in a civil court requesting it the right to worship Ma Shringar Gauri, the goddess who was on the wall of GYANVAPI Mosque complex. So they want to worship this Ma Gauri who was located on this complex. That is their petition. Looking into the seriousness of the issue and having the religious sentiments attached to the issue, Supreme Court moved this court to District and Session Court. To the Varanasi District and Session Court, this case was moved. Now, so the management committee of this GYANVAPI Mosque, they asked the court to reject this request. To reject this request, this GYANVAPI Mosque committee asked the Supreme Court, asked the Session Court. This Session Court rejected the plea of this management committee of the GYANVAPI Mosque. Okay, so that is the issue. The court rejected the plea of committee. What is this plea of the committee? The committee is asking to reject this maintainability of the civil suit that was filed by this Hindu woman. So that was the case. Now, how we are going to take this issue? First, we'll see the background of this mosque, and then we will hear both sides of the arguments, and also we'll see the court's hearing. What's the court observed in this case? Okay. Now, what is the background of this mosque? Aurangzeb, around 1669, he ordered to build a mosque. Where he ordered to build a mosque? So there was a temple, Adi Vishveshvara temple, which is a Shiva temple. So he ordered to destroy this temple and construct a mosque in this place. So, see, Aurangzeb is not a secular person. He destroyed temples, he whitewashed the paintings even on the forts, even in the mosque. So he ordered for the white paintings of the paintings. He did not encourage musicians, historians. He's not secular. But compared to the Akbar is more secular. He even temples were constructed during the period of Akbar. Okay. So this temple was, the initial temple was destroyed. In that place, a mosque was built. So they used it while constructing the mosque. So they used the same plinth, they used the material of this temple for the construction of the mosque. So now, here there is a temple, instead of that, here now we have a mosque. So later on around a century later, in the 18th century, Rani Ahilya of Holkar, she's from Indore. She ordered for the construction of a temple in this place. Which is the present Kashi Vishwanath temple. Initially the temple is here, later on it was built over here. This is the present temple. So now we'll see the pictures of it. So you can observe here. So this is the temple which was built later. Here we have Kashi Vishwanath, the temple corridor, which was inaugurated by our Prime Minister Modi. So here we have this GYANVAPI Mosque. Now, so we can also observe how even the walls, the pillars of the temple were used for the construction of the mosque. In the 2021, so a court ordered for the survey of this area. When they ordered for the survey, they found a Shiva Linga, in a well in the GYANVAPI complex. They found a Shiva Lingam in the GYANVAPI complex, whereas Muslim committee claimed that is a fountain. Whatever, the controversy is still going on. So for now, we have to understand earlier there is a temple that located here, over that a mosque was built. So that is the background of this issue. Now we will see both sides of the arguments and the laws that were involved in this issue. Okay. So as I told you earlier, Mughal Emperor Aurangzeb ordered for the demolition of the Vishveshvara temple and replacement of it by mosque. And later on, a Kashi Vishwanath, the present temple, was built by Rani Ahilya Holkar of Indore. So on what laws the Muslim Management Committee was arguing? The laws involved in this issue are the major contentious issue, the act the Places of Worship Act 1991, the Waqf Act 1995 and Kashi Vishwanath Temple Act 1983. We'll see one act after another and we'll see the both sides of the argument. First we'll take Places of Worship Act 1991. What is this act is talking about? 15th August 1947. This act prohibits, the Places of Worship Act prohibits conversion or changing the nature of any religious place that was constructed before 15 August 1947 or encroached before 15 August 1947. Listen carefully. So what this act is saying, so whatever be the nature of the religious place, either it is an mosque or temple, if the mosque was destroyed and temple was constructed and temple was there earlier and mosque was constructed, whatever it might be. So it is saying whatever the religious place, what is the nature of it, either the Muslims or the Hindus or the Jains or Buddhists, that existed, the status of it before 15th August 1947 will not be changed or will not be challenged in any court. That was this act is talking about majorly. It prohibits the conversion of the nature or this religious place further. There is only one exception, that is Ayodhya. Ayodhya dispute is the Ayodhya Babri Masjid dispute is the only exception for this act. Why? Because this act took place at this was brought down in 1991 when this Ayodhya dispute, Babri Masjid Ayodhya dispute is already in the court. It is under litigation. So it was filed in the court. So that will not cover under this Places of Worship Act. That is the major point. So the Varanasi temple will come under this act. The Kashi Vishwanath temple will come under this act. Ayodhya won't, because it is under litigation. That is their first argument. Now, what is this Hindu side's argument? What the other side argument? They are saying that we are worshipping the goddess. We are worshipping the goddess till 1993. Even after 1947, till 1993, we are worshipping the goddess in the GYANVAPI complex. After 1993, they are worshipping annually, once in a year. So, this was taking place after 1947. It is continued after 1947. So, the request, what they claimed, that we are worshipping after 1947, still it is existing. So, this Worship Act will not apply for this. See what the court is saying, listen carefully. What is this act is saying? Whatever the nature before 1947, they are not going to change it. Fine. But we are worshipping even after 1947 till 1993 we are worshipping. So that means, so we fall in this area too. They will come under this area. So we won't come under this dispute won't come under this Places of Worship Act. That is their major argument. So we'll see here. So what are the points I told you earlier? So we'll go through them. First, the nature of all places of worship except the Ayodhya, the one in the Ayodhya, shall be maintained as it was on August 15, 1947. So what does it mean? Whatever be the nature before 1947, it will be continued. No one can file a suit in a court. That is this act. No encroachment of any such place, that is prior to that date, prior to this date, cannot be challenged in courts. They cannot challenge. That is this act. They are saying this temple is before 1947. Muslim side is arguing it is before 1947. That's why it falls under this Places of Worship Act. Hindus are saying we are worshipping even after 1947. Till 1993 they are worshipping. So we'll fall here. So they should be allowed to pray in the GYANVAPI complex. Next. So as I told you, these are the points. Since 1993 the prayers have been allowed on a designated day annually. Okay. So this is the argument based on the Places of Worship Act. So what is the next act that Waqf Act? Waqf Act 1995. So what are the arguments from the Muslim Management Committee? They are saying this Gnanavapi mosque will come under Waqf property. It is a Waqf property. On what basis they are saying it's a Waqf property? 1. So earlier in the Varanasi Gazette, a notification was issued claiming this mosque was a Waqf property. First one, in the Gazette it was mentioned the Gnanavapi mosque as a Waqf property. First. Second, Allahabad High Court says that if any past or very old, ancient times, medieval times, religious places, and it is used for the religious purposes like Muslim burial grounds or Muslim prayer grounds, so they were dedicated to the god, so they will be treated as Waqf property. Guys, I'll explain you again why it is treated as Waqf property according to Muslim Management Committee, why they should consider in that way. First, it was mentioned in the Varanasi Gazette. That is first argument. And second argument, they are saying according to Allahabad High Court earlier ruling, any ground used for any land used for religious purposes, ancient, any land ancient one or the medieval very past one used for religious purpose, that is Muslim burial grounds or Muslim mosque or prayer grounds, those things will come under Waqf property. That means earlier whatever you are used for the religious purposes, very past one, old ones, conventionally they are using from many years, that will come under Waqf property. Based on these two, they are saying it's a Waqf property. One argument. This is one. And they are saying when it is a Waqf property, the civil suit should come under Waqf tribunal. The civil should be filed under Waqf tribunal. So this case, whatever they are discussing, it should not be under the court, it should be under Waqf tribunal. This is the arguments from Muslim side. Now we'll see the arguments on the other side. So what are the arguments on the other side? You are saying it's a Waqf property. Mentioning it in a gadget doesn't give them a title as Waqf property. It's a revenue record. Mentioning in a revenue record does not give a title to that property. First. Second, what is this argument? Very old places, very old lands which were used for religious purposes will come under Waqf property. Which is used for Muslim religious purposes will come under Waqf property. For that, what they are countering? When you are saying very old or past, immemorial places, Vishveshvara temple is much earlier to the mosque. So, it's never a Waqf property. The court says Adi Vishveshvara temple is much before, much earlier, very past ones. So, it won't come under Waqf property. That is an countering argument for this. Next, they are saying the civil suit should be filed in Waqf tribunal. The court says, see, the tribunal can entertain the cases within the community or outside the community, but they cannot stop. The Waqf Property Act cannot stop the claims outside the community. If I am having claims over the property, so I am outside the community, so we cannot go through the Waqf tribunal. This is the arguments under Waqf Act 1995. We'll see this. So as I told you, what they are saying, it is a Waqf property. The suit is filed under Waqf property, so it should come under Waqf tribunal, which is in Lucknow. So on what basis they are saying? It is published in the Varanasi Gazette. So the mosque is built on Waqf land. Second, what is the Allahabad High Court is saying? Any land that is time immemorial. Immemorial means very past, okay? For a religious purpose. When you are using it as for a religious purpose, such as for mosque or burials, that should be treated as Waqf. So this is the argument from the Muslim side. So what is the argument of Hindus? Being in a revenue record doesn't create a title. First one. Second, you are saying we have to put it in a Waqf tribunal, but to solve the disputes, Waqf tribunal majorly says within the community, it doesn't mean the claims from outside community should not be entertained by courts. That is another argument. And the court is also says, So this temple earlier belonged to deity Adi Vishveshvara, time immemorial. The same term they used. The very past it belonged to Adi Vishveshvara. So it could never be a work property. It's never been a work property. So we have dealt the two acts. What is the other? Kashi Vishwanath Temple Act. The other act was Kashi Vishwanath Temple Act. So what is the arguments from this side, from the Muslim Management Committee side based on this act? They are saying this act defined the temple land. This act defined the temple land. So under that, this mosque doesn't come. Second, the board of trustees of Kashi Vishwanath, which were formed under the Kashi Vishwanath, they never interfered into these matters. They never interfered either for the darshanas or the prayers or the pujas. So that is another argument. They never intervened. This is the arguments from the Muslim Management Committee side. So what is the argument from Hindu side? So it's saying that the land temple even includes the mosque. Second, when these people are not working well, so they're not performing the duties, that is why the Hindu women filed a civil suit. They're not interfering, so they're requesting the prayer, requesting to pray in the GYANVAPI complex. So that is why they will have to interfere. So this is the arguments on both the sides under the Kashi Vishwanath Temple Act. So we'll see that. So it is saying that the temple land was clearly demarcated and the board of trustees appointed under the law did not interfere in the case. Defines the temple to hold doesn't bar the mosque premises. So it doesn't bar the mosque premises, that is one. And the second, they are not working, so they are not interfering. That is why the woman has to file a civil suit. So this is the argument on both the sides. Okay. So till now what we have seen, background of the mosque and the Kashi Vishwanath temple, and we have seen the three laws under which this case was going on, and we heard both the sides of the arguments. But now students, so the question majorly, rather than asking on how the arguments were going on, what happened in the GYANVAPI mosque, the major issue, the question, the probable mains question could be on the topic Places of Worship Act 1991. So we'll take this topic in detail. So before that, so what is the court observations in this? The court said, finally what the court said in the earlier arguments, they said the petitioners, the women, they were just asking for the right to worship, which is a civil right and fundamental right. They're worshipping for they're requesting for the worshipping, which is a fundamental right and a civil right. They are not claiming any ownership of the disputed property. So that was the final observations of the court, and they maintainable so they took the case. Okay. So as I said earlier, so the probable mains question could be on Places of Worship Act 1991. Why this could be a important question for the mains? Because see, many suits, the experts are thinking, so this may lead, this dispute or this judgment of Varanasi district court may lead to many civil suits all over the country need to be filed in a courts. So we are going to see many cases, many suits based on this act, challenging this act. So in future, further, say anyways, these people are going to High Court or to the Supreme Court, they will go, this case is going further. So in the same way, the civil suits, many civil suits are going to be filed in the courts. So we'll see in detail of this act from the mains perspective. Okay. So what is here? What we will see here, first we'll see the provisions of the act. What are the provisions? What are the exemptions? And we'll also see why center at the time has to introduce this act, why they brought this act, what are the challenges, why people are challenging this act, on what basis they are challenging. This is another thing, and we'll also see how this is going to get more suits, like on what basis they are going to file against this act. Now, as I told you earlier, what is this act? So, what does it do? It prohibits the conversion of the place of worship and religious character of the place in India's before, that was the time of August 15, 1947. I'll explain again as we have already seen, but I want to tell you guys, any mosque or temple that was existing, the character of it before 1947. So that will be existing after that. We should not challenge that. We should not convert that. It seeks to prohibit the conversion of a place of worship that was at the time of independence. How it is exact undertaken? So it will be going to continue. So what are the exceptions under this act? As we have already discussed, Ayodhya dispute was in the court at that time. So L.K. Advani conducted Rath Yatra. So for the Ram Janma Bhoomi. So Babri Masjid riots took place at that time. So many events, after the demolition of the Babri Masjid, many things were going on in 1990s. So Ayodhya, Babri Masjid and Ram Janmabhoomi dispute was already in the court. So this will not come under this act, first. Second, historical, ancient and historical monuments, archaeological sites that were covered under this act will also be exempted from the Places of Worship Act. Okay. So this is the exemptions. Now, why was this act introduced? Why center has to introduce? The P.V. Narasimha Rao at that time, the Prime Minister of that time, had to introduce because the country cannot entertain the issues further based on these conversions, or we can't allow another riots where the 2000 people were killed. So that's one of the major reason to uphold the secular nature of our constitution and of our country. So they have to bring this act, the Places of Worship Act. What are the challenges to this act? What are the challenges? See, I'll give you an example. One civil suit that where the Supreme Court entertained, when a civil suit that was entertained by the Supreme Court. One is here. So the BJP leader and lawyer Ashwini Kumar Upadhyay, he challenged this act in court. On what basis he challenged? He said it is intervening the principle of secularism. That is one. The another important point is this. What this point is saying, so the court is saying, what is this act is saying? I can't question whatever happened, the religious characters of the temples. I can't take them before it. Suppose any illegal encroachments happened. After, this is a temple and I'm giving an example. This is a temple that was before 1947 also, it's a temple. Later on, encroachments took place and conversions took place, encroachments, and it was turning into mosque. So now, what can I file a suit on this? So they are saying that we can't file a suit based on the encroachment. So many encroachments are taking place onto the religious places and the pilgrimage places. So the court what said? They can't file a suit. So they are saying the center barred the remedies against the illegal encroachments on the places of worship and pilgrimages. We cannot file a suit or approach the High Court under Article 226. It is taking away the judicial review. What this act is doing? I can't file a suit. If at all any illegal encroachments happened, we can't file a suit. So it is taking away the judicial review, which is a basic structure of a constitution. Okay. So this is a major point that is challenging this act. Now we will see what are the other grounds that it was challenged. As I told you, for example, the constraints of judicial remedy. So the contention on cut-off date, as this date, August 15, 1947, they consider it as an arbitrary and irrational. Next, issues of exemption. When you exempted the birthplace of Rama, which was Ayodhya, why are not allowing to file a complaint on that of Lord Krishna's birthplace? And another case was filed in this May, claiming that a mosque need to destroy, which was located on the birthplace of Krishna. They want to move the mosque on the birthplace of Krishna. That is another civil suit that was filed under the Places of Worship Act 1991. So restrictions on the fundamental rights to practice religion, and it is not in the spirit of secularism. So please go through that. Now, what Supreme Court at that time claimed? What are the observations that it was? It gave the status quo. It said the Places of Worship Act 1991 will continue. That was the ruling that was given by the Supreme Court at that time. What are the observations that it made? It said in the final judgment of Ayodhya issue also that the Places of Worship Act 1991 will continue because it imposes this act imposes a non-derogable, unquestionable obligation towards enforcing our commitment to a secularism. So we have to, as our constitution is committed towards secularism, so this act should continue. And it also went and also said the historical wrongs cannot be remedied by the people by taking laws in their hands. And also it says that we can't use an act to oppress the people in the present and the future. By using us, they are saying it like this: the historical wrongs or whatever happened in the past, that should not impact the lives of the people, or that should not oppress the present and future of the people of this country. So what we have seen, the Places of Worship Act, what it is pretty clear, and what are the exemptions of it, and why many civil suits are filing in the courts based on this act, why, on what basis they are challenging this act, and what is the observations of Supreme Court on this act. What did it say? It will continue. Status quo. So whatever the temple, it's going to be a temple. If it is a mosque, it's going to be a mosque. So a status quo is given by the, and it also, Supreme Court and also said that our historical wrongs and the past should not implicate the present and the future of this country. What are the implications of this case? As I told you, so the GYANVAPI Mosque in Varanasi is one issue that is challenging this 1991 Act, Places of Worship, and Shahi Mosque in Mathura. So it's a birthplace. The mosque was the spot that claimed is the birthplace of Lord Krishna. It was constructed in 17th century. So this is another issue. See, even at that time, when the Babri Masjid issue was going on, the Ram Janmabhoomi dispute was going on. So majorly, at that time, the people want to change the Ayodhya. They want to go for the birthplace of Rama, Ayodhya dispute, and then Varanasi, and then the Mathura. These were the issues coming from the 1990s. Since 1990, we are continuing having the issues. So they're expecting more cases will be filed against challenging this act. So I want you to understand this question, and please guys, please answer it. Just give an attempt to this question. So what is this question? The Places of Worship Act 1991 will disturb the secular nature of our Indian society. Critically analyze. So what we'll do when we are seeing a question, first of all, we have to divide it into parts. We'll divide the question into parts. So first part, we will explain what is this Places of Worship Act. On what basis we are challenging. This part 2. Next, what we'll do? Will it disturb the secular fabric of our state? Will it not? Yes, it will disturb. So you'll write how the case was filed in Mathura. A civil suit was filed in Mathura instead of Shahi Dag Mosque. So in such a way, many places are going to come. So based on this, we'll write how it disturbs the secular fabric. And second, how will it not? So we can't say how will it not, but we can say that so time and again. So Indian secularism is tested, and we should strong. The Indian society's secular values stood strong against these issues. Okay, that is one. And second, we have belief in our courts that it will uphold each and every value that was given our constitution. So we believe in our courts, so that will uphold the secular nature. That should be a point here. So in that way, divide the question. So it is a 10-marker question. Don't write too many words. Just write what is this act, what are the challenges, few challenges, because the question is critically analyzed. So will it disturb or will it not? So in that way, you have to attempt the mains question. Okay, guys. So please write this question, and thank you. We'll see in the next topic.